Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. We got great question here today from one of our YouTube subscribers. Hey Patrick, what is the best type of estate plan for snowbirds when we reside in, spend time in multiple states? We have a lot of clients that fall into that situation. They are considered snowbirds. They spend the winters down in the warmer climates and they come back up to the Northeast during the summer months where the weather is typically a little cooler, right? But folks, you need to consider things like, hey, how are we going to avoid probate court, not just in one state, but in multiple states? How are we going to avoid or reduce taxes, estate death tax, maybe income tax? How do we provide bloodline protection for our children and grandchildren? And what if Bill and Mary become completely incapacitated? How do we pay for that $18,000 per month nursing home? What are the rules of engagement for Medicaid and so forth? So multiple states, folks, my advice is, first and foremost, you want to work with your elder law attorney and create a trust, right? And that's like your treasure chest. That's a foundation of your estate plan, folks. And if you have your house here, say in Massachusetts, you need to get that house transferred to your trust. If you have a second house in another state, you also need to work with an attorney in that state to transfer that second or maybe even third house into that trust, because sadly people die, but trusts do not. That's important to know that. And that's how you avoid the metaphorical first-headed monster, probate court. Why do folks want to avoid probate? Costs too much, takes too long. And now you're multiplying that in more than one state. Let's talk about the second-headed monster, taxes. For example, Massachusetts has an estate death tax. Some of our clients from Massachusetts have now changed their residency to the state of Florida or another state that does not have a state-level estate death tax. Massachusetts has a death tax. And if your estate is greater than $2 million here in the Commonwealth, Massachusetts Department of Revenue will have automatic liens on your real estate here in the Commonwealth, and it's an obligation for you to either prove to them that you do not owe estate tax or pay the estate tax. And game changer now, if you spend your summers up here in Massachusetts, but you become a resident, we'll say the state of Florida, and you have to do that legally by register and vote in the state of Florida, changing your driver's license, filling out a declaration of residency in the state of Florida, and you have to legitimately live there more than 6 months. And you should be filing your income tax return in Florida as well. That way you qualify maybe as a Florida resident. And that way you're taking the second-headed monster completely off the table for state-level estate death tax. So if you have, say, a $2.5 million estate, $3 million estate, no state estate death tax in Florida. There's still a federal estate tax, but it's up there over $13 million per person. Most folks do not have to worry about the federal estate tax because it is so high. So that could be a prudent way, a prudent strategy to have your residency changed, so long as that works for you, if you think you have a taxable estate for the estate death tax. Folks, any state, you want to make sure that you have proper bloodline protection in your trust to slay potential financial creditors and predators, be it for your spouse. If they decide to remarry, you want asset protection in there so the new beau does not take the family assets. We see that quite often. That's not good. So you want to put the true and tried family bloodline asset protection language in your trust. And even if it doesn't benefit your spouse, you want that bloodline protection to benefit your children and even your grandchildren. So that's not automatic. You want to instruct your elder law attorney to put that true and tried internal code. Folks, another really important recommendation is your power of attorney, your healthcare proxy. Typically, they're very state specific. You would want custom language in your durable power of attorney saying it should be recognized in all states and all jurisdictions, including but not limited to Massachusetts, Florida, South Carolina, or whatever states you may spend a lot of time in, because they can be very state specific. And I would recommend you also do that with your healthcare proxy, because if a specific state does not accept it, they may require that you petition the probate court for conservatorships, guardianships. You want to make sure you have the sufficient language in the four corners of that instrument in your elder law toolbox, folks. I refer to it as the Big Six disability planning. They are just not tools. They are power tools that you need in your elder law toolbox to slay disability probate. And folks, then you want to be mindful of the fourth-headed monster, long-term care needs. You want to think about, as you're in the late fourth quarter of life, if either you or your spouse became completely incapacitated, sadly, what state would you want to spend your final chapter in? Do you want to be in Florida? Do you want to be in Massachusetts? I see a lot of our clients move down to Florida, become snowbirds for 20 years, and then in the late fourth quarter of life, when one passes away and the other's health is significantly compromised with incapacity, they may move back to Massachusetts to be closer to their children, caregivers, to keep a good eye on them, to manage and monitor their long-term care health needs in an assisted living facility, memory care unit, or skilled nursing facility, sadly. And then you want to think about the rules of engagement with Medicaid. They're similar, but they're different in each state. So you want to consult with a qualified, experienced elder law attorney in the state that you think you may be spending your final chapter in. And if you're unsure, my recommendation would be talk to elder law attorneys, maybe in the state of Massachusetts and Florida, if you're not sure where you're going to end up later in life, because you need to know the rules of engagement. Typically, from my experience, the best way is pre-planning, not crisis planning. So I hope that question helped you with how to create an estate plan if you are considered a snowbird. Don't wait for a rainy day or a snowstorm. Get it done when you're alive and well. Folks, thanks for being here. If you'd like to learn more, go to elderlawcare.com. Make sure you click the subscribe button, click that notification bell. We'll keep you updated. Thanks for being here at elderlawcare.com.